Friends, welcome to Prashant IAS. So friends, in the last class, we were discussing about directive principles of state policy. And in this class, we will continue our discussion further. So friends, first of all, we will start our discussion with fundamental rights versus directive principles of state policy. Means if there is any conflict between fundamental rights and DPSP, then who will win? Then who will prevail? Okay? So let's start. So friends, first of all, Article 37 says that directive principles are not enforceable in the court of law. Nevertheless, they are fundamental in the governance of the country, and it is the duty of the state to incorporate these principles in the laws enacted and policies formulated. Now, what does it mean? So, first of all, what Article 37 is saying? So, first of all, Article 37 is saying that directive principles are not enforceable in the court of law. Okay, so what is the meaning of this line? So, this line means that directive principles or DPSP are not enforceable in the court of law. Means if government is not implementing the DPSP, if government is not implementing the principles given in DPSP, then also you cannot force the government to implement these principles. Okay, so if government is not implementing directive principles of state policy, then you cannot file a case in the court of law against the government, and you cannot force the government to implement these principles. Means it is up to the choice of the government that if government wants, then government will implement, but if government doesn't want, then government will not implement. So it is up to the choice of the government. Okay, means you cannot file a case in the court of law against the government if government is not implementing these principles. Okay, and you cannot file a case in the court of law if government is not implementing these principles, and you cannot force the government to implement these principles. Okay, but friends, then further Article 37 is saying that then also these principles are fundamental in the governance of the country, and it is the duty of the state to incorporate these principles in laws enacted and policies formulated. Now what does it mean? So it means that even DPSP are not enforceable, then also directive principles of state policy are fundamental in the governance of the country. DPSP are the basis of the governance of the country. Okay, so directive principles of state policy are the basic principles, are the fundamental principles in the governance of the country. And whenever state will make any law, whenever state will make any policy, then state has to make that law or policy according to DPSP, according to the guidelines given in DPSP. Okay, so whenever state will make any policy or law, then state has to make that law or policy according to the guidelines given in these principles, according to directive principles of state policy. Okay, so this was what Article 37 is saying. Okay, so what Article 37 is saying, that DPSP are not enforceable in the court of law. Means you cannot force the government to implement DPSP if government is not implementing them. But then also DPSP are fundamental in the governance of the country, and it is the duty of the government, it is the duty of the state to follow these principles whenever state will make any law or policy. So this was what Article 37 was saying. Okay. Now friends, then came State of Madras versus Champakam Dorai Rajan case 1951. Okay, and what happened in State of Madras versus Champakam Dorai Rajan case? So in Champakam Dorai Rajan case 1951, Supreme Court held that the laws made to enforce directive principles cannot override fundamental rights, and they have to run in subsidiary and in conformity with fundamental rights. And in case of conflict between fundamental rights and DPSP, fundamental rights shall prevail over DPSP. Now what does it mean? So friends, I will give you one example so that you can understand it very easily. Now friends, we know that Article 44. So yesterday I told you Article 44. So what Article 44 says? So Article 44 directs the government to implement Uniform Civil Code. Okay, so what Article 44 is saying? Article 44 is directing the government to implement Uniform Civil Code. Now what is Uniform Civil Code? This I have explained it to you in last class. So if anybody is not clear with what is Uniform Civil Code, then you should watch the last lecture. So friends, what Article 44 is saying? So Article 44 is saying that government should implement Uniform Civil Code. Now friends, suppose if government made any law, if government has made any law and that law is actually inspired by Article 44, means government has made that law to implement the Uniform Civil Code. Okay, now friends, suppose this law is violating right to the freedom of religion. Now we all know that right to the freedom of religion is a fundamental right. Okay, so now what is the entire scenario? So the entire scene is that government has made a law and government has made that law to implement a DPSP. Why? Because achieving Uniform Civil Code is a DPSP given under Article 44. But actually that law is violating fundamental right. Why? Because right to the freedom of religion is a fundamental right. So now Supreme Court has said in Champakam Durai Rajan case 1951 that now Supreme Court or High Court will declare that law as null and void. Okay, so Supreme Court has said that if any law is made to enforce any DPSP and if that law is violating fundamental right, then that law will be unconstitutional and void. Then court will declare that law as invalid. Okay, so Supreme Court has said in Champakam Durai Rajan case that if state makes any law to enforce any DPSP, to enforce any directive principle of state policy, then that law has to run in according to the fundamental right. And if that law will violate any fundamental right, then that law will be declared unconstitutional, invalid and void. Okay, so here the law was made to enforce Uniform Civil Code, but that law was violating right to the freedom of religion, so that law will be declared unconstitutional and void by the court. Okay, now friends, this was just a imaginary example, it is not a real example. So what happened in Champakam Durai Rajan case? So in Champakam Durai Rajan case, Supreme Court said that the laws made to enforce DPSP cannot override fundamental rights. Okay, and if there is any conflict between fundamental right and DPSP, then fundamental right will prevail. So this was what Supreme Court said in Champakam Durai Rajan case 1951. Now friends, let's move further. So friends, then came Re-Kerala Education Bill case 1957. So what happened in Re-Kerala Education Bill case 1957? So in this case, Supreme Court, realizing the importance of DPSP in establishing a welfare state, adopted the theory of harmonization, in which court declared that in general, DPSP cannot override fundamental rights. However, in fixing the scope and ambit of fundamental rights, court must not completely ignore DPSP and should try to give effect to both as much as possible. Because there is no inherent conflict between fundamental rights and DPSP. It is thus the responsibility of the court to implement DPSP along with guaranteeing non-violation of fundamental right. Now what does it mean? So friends, now what happened that here Supreme Court finally realized that DPSP are very important for establishing a welfare state. Okay, so what happened that now Supreme Court finally realized that directive principles of state policy are very essential tools for establishing a welfare state. Without DPSP, it is very difficult to convert India into a welfare state, to make India a welfare state. So DPSP, directive principles of state policy, are the most important tool to make India a welfare state. Okay, so now court finally realized that DPSP are very important for making India a welfare state. Okay, So now friends, court adopted the theory of harmonization. So now what is this theory of harmonization? So it means that now Supreme Court said that it is the primary duty of the courts to implement the fundamental rights. Okay, so what is the primary duty of the courts? So the primary duty of the courts is to establish the fundamental right, is to enforce the fundamental rights. But friends, then Supreme Court said that in enforcing the fundamental right, in giving effect to fundamental right, court should not forget the DPSP. Court should not ignore the DPSP completely. Okay, so court should try to give effect to both as much as possible. Court should also try to enforce fundamental rights and DPSP both. Okay, so it is the primary duty of the court to enforce fundamental rights, but in enforcing fundamental rights, court should not completely ignore, court should not completely forget about DPSP. So court should try to give effect to both DPSP as well as fundamental right. Means if there are any chances of harmonization, if there are any chances of harmonization between DPSP and fundamental rights, then court should use these chances. Then court should try to give effect to DPSP as well as fundamental right. So now it is a responsibility of the court to implement directive principles of state policy plus fundamental rights. Now friends, I know that this is little bit technical, so I will give you one example so that you can understand this very easily. Okay, so friends, in the last slide we took the example of Article 44. So what Article 44 says, that state should try to enforce Uniform Civil Code. So now in this slide also I will take the help of the example of Article 44 and I will try to explain you this concept. So friends, now imagine that state made a law, and state made that law after getting inspiration from Article 44. Means government made that law. First thing, government has made a law, then government made that law to enforce Uniform Civil Code, to implement Uniform Civil Code. Means government has made that law after getting inspiration from DPSP. Okay, so government has made that law to implement a directive principle of state policy. Why? Because Article 44 is a DPSP. Okay, so government made a law to implement Uniform Civil Code. But friends, now suppose that law is violating right to the freedom of religion, and definitely we all know that right to the freedom of religion is a fundamental right. So now what court is saying in this case? So now court is saying that, now suppose friends, the law which government made has 20 sections in it. So we know that there are sections in any law. Okay, so the law which government made has certain sections in it. Now suppose there are 20 sections in that law. Okay, so government made a law to enforce Uniform Civil Code and there are 20 sections in it. Now suppose friends, the 5 sections of that law are totally violating the freedom of religion. They are totally violating right to the freedom of religion. So definitely there are no chance of harmonization between these 5 sections of that law and right to the freedom of religion. Why? Because these 5 sections of that law are actually killing right to the freedom of religion. These 5 sections are actually violating right to the freedom of religion. They are trying to totally snatch right to the freedom of religion from the people. Okay, so now there is no chances of harmonization between these 5 sections of that law and right to the freedom of religion. So now court is saying that in this case, the primary duty of the court is to protect fundamental right. Court is a protector of fundamental right. So now primary duty of the court is to protect the fundamental right. So in this case, what courts will do? In this case, courts will declare those 5 sections of that law as unconstitutional and void. Okay, so what court will do? Now court will declare those 5 sections which were violating right to the freedom of religion as religion. So court will declare those 5 sections as unconstitutional and void. Okay, so this was the first thing. Now friends, I told you that there are total 20 sections in that law. Okay, so now court has declared 5 sections as unconstitutional and void. So how many sections are remaining? So now 15 sections are remaining. 15 more sections are remaining. Now suppose friends, these 15 sections of that law are not violating right to the freedom of religion. Okay, so either they are not violating right to the freedom of religion at all, or they are violating it in a very little manner. Okay, so either they are violating it in a very little manner, means it can be adjusted. Okay, it can be ignored. So even though they are violating right to the freedom of religion, but it can be ignored, it is very little. Okay, or they are not violating at all. Okay, so there are two conditions. The first condition is that the remaining 15 sections of that law are either not violating right to the freedom of religion at all, and second condition is even if they are violating, then also that violation can be ignored, means that violation is very little, that is negligible. So now there are a chance of harmonization between DPSP and fundamental rights. So now Supreme Court is saying that now what court will do? Now court will not declare that law, that these remaining 15 sections of that law is unconstitutional and void. Okay, so now what courts will do? Now courts will ensure that these 15 sections will remain in operation, and also these 15 sections should not violate any fundamental right. Okay, so now in this case, court will not declare those remaining 15 sections of that law as unconstitutional. Okay, so court will not declare them unconstitutional. Court will let them survive. Okay, but now court says to ensure that these sections should not violate any fundamental right. So this was the principle of harmonization. So principle of harmonization says that it is the duty of the court to implement the fundamental right and directive principle of state policy both. Okay, so if there are any chances of harmonization between DPSP and fundamental right, then it is the duty of the court to find that harmonization and to implement DPSP and fundamental right both. Okay. Now friends, however, if only one interpretation is possible, that is, court has no choice of harmonization, then court have to implement over fundamental rights. Okay, now what does it mean? It means that if the situation is like that there is no harmonization possible between a law which is made to implement a DPSP and the fundamental right, then court has to declare that law as unconstitutional and void, and court has to implement the fundamental right. Now what does it mean? So again we will take help from our example for understanding this concept. So I told you that what happened, that government enacted a law, and that law was enacted to give effect to a DPSP under Article 44, means Uniform Civil Code. Now there were total 20 sections in that law. So earlier what happened, that 5 sections were violating right to the freedom of religion and 15 sections were not violating it. And even though they were violating, then also it was negligible. So what court did? So court actually declared the 5 provisions which were violating right to the freedom of religion as unconstitutional, and court upheld the validity of 15 remaining sections which were not violating right to the freedom of religion. But now suppose friends, there is another condition. Now the condition is that all the 20 sections are violating right to the freedom of religion. All the 20 sections of that law are deliberately killing right to the freedom of religion. If that law is implemented, then all the 20 sections of that law will snatch the right to freedom of religion from the people. Means all the sections of that law are actually violating right to the freedom of religion. So if the law is implemented, then right to the freedom of religion will be violated. Means there is no choice. There are no chances of harmonization. So now Supreme Court is saying that if there are no chances of harmonization, then what court has to do? Then courts have to declare that law as unconstitutional and void. Courts have to implement fundamental right. Why? Because fundamental rights are very, very important. Okay. So friends, then what happened? That because of this interpretation, Supreme Court declared Bank Nationalization Act 1969 and Privy Purchase Act 1971 as unconstitutional, because even these laws were there to achieve DPSP under Article 39 Clause V and Article 39 Clause C, they were violative of fundamental rights under Article 14, 19 Clause 1 Subclause F, 19 Clause 1 Subclause G and Article 31. Now what does it mean? So friends, what happened that Parliament enacted two laws. The first law was Bank Nationalisation Act 1969 and the second law was Privy Purses Abolition Act 1971. Okay, now friends, these two laws, both of these laws were enacted to implement the directive principle of state policy under Article 39 Clause B and Article 39 Clause C. Okay, so both of these laws were actually enacted to implement the DPSP under Article 39 Clause B and Article 39 Clause C. Now what is Article 39 Clause B and Article 39 Clause C? So I taught you about this in detail in last class. So if you actually want to study Article 39 Clause B and Article 39 Clause C again, then you should watch yesterday's lecture, okay, because there I explained it in much detail. Now friends, what happened that what Parliament did, that Parliament enacted two laws. The first law was Bank Nationalisation Act 1969 and the second law was Privy Purses Act 1971. Now, what is the meaning of bank nationalization? So, what happened in bank nationalization? That government actually took over the ownership of banks from the private hands to the government of India. Okay, so what happened in bank nationalization? So earlier all the banks were private. Okay, but after bank nationalization, government took over the ownership of these banks from the hands of private individual to its own hands. So what happened? So actually these private banks were the property of some private individual. Okay, so definitely bank were the property of any individual. Why? Because bank was like a company. So actually when government snatched the ownership of bank from its owners, so first of all government deprived them from their right to property, and right to property was guaranteed under Article 19 Clause 1 Subclause F and Article 31. So Article 19 Clause 1 Subclause F and Article 31 were right to property and they were fundamental rights. Okay, moreover bank was also their profession was banking, so government also deprived these individuals from their profession, and Article 19 Clause 1 Subclause G guarantees right to the freedom of profession, trade, business. So banking was their profession, banking was their business, and what government did? Government actually deprived these individuals from their profession, from their business. Okay, so actually there was no harmonization possible between these laws and fundamental rights. And what Supreme Court said in Re-Kerala Education Bill? So Supreme Court said in Re-Kerala Education Bill that if only one interpretation is possible, that is court has no choice of harmonization, then courts have to implement over fundamental rights. Then courts have to enforce fundamental rights. So what happened, friends? Courts didn't have any choice. So courts declared, means Supreme Court declared Bank Nationalisation Act 1969 and Privy Purses Act 1971 as unconstitutional and void. Okay, so this was the complete story. Now let's move further. Then friends, what happened? That now Parliament held that judgment of the court was coming in the way to enact social legislation to bring social reforms in the larger interest of the society. Now what does it mean? So now Parliament was saying that whenever I am making any law to give effect to any DPSP, when I am making any law to do social reform, whenever I am making any law in the interest of the society, then Supreme Court is actually declaring that law null and void. Okay, so Parliament was saying that whenever I am making any law in the interest of the society, then Supreme Court is declaring that law as null and void, as unconstitutional. So actually the judgment of the court is coming in the way to enact social legislation. So now what Parliament did? So now Parliament through 25th Amendment Act 1971 amended Constitution and added Article 31 capital C. Now what does it mean? So it means that what Parliament did? Parliament amended the Constitution. And by constitutional amended, Parliament added one more article. So Parliament added Article 31 capital C in Indian Constitution. Now friends, let's see what was the language of Article 31 capital C. Means what Article 31 capital C was saying. So Article 31 capital C was saying that if state enacts a law to give effect to principles under Article 39 Clause B and 39 clause C. And in the process, if the law violates three fundamental rights under Article 14, 19 and 31, then the law shall be declared invalid only then the law shall not be declared. Okay, then the law shall not be declared invalid only on this ground. And further, no such law can be questioned in the court of law. Now, what does it mean? So it means that suppose if state makes any law, okay, suppose if parliament makes any law and parliament has made that law to give effect to DPSP given under Article 39 clause B and 39 clause C. Okay, so if parliament has made any law to implement the DPSP given under Article 39 clause B and 39 clause C, and then that law actually violated the fundamental rights given under Article 14, means right to equality. Fundamental right given under Article 14 means equality before law and equal protection of the laws. Article 19 means right to freedom. Article 31 means right to property. Then only on this ground that law is violating Article 14, Article 19 and Article 31, then only on this ground that law cannot be declared invalid. That law cannot be declared unconstitutional and void. Now friends, I will give you one example so that you can understand it more easily. So suppose friends, Parliament made one law to implement Article 39 clause C. Now what is Article 39 clause C? So Article 39 clause C says that state should ensure prevention of concentration of wealth in few hands. Okay, means it is the duty of the government to ensure that wealth should not be concentrated, money should not be concentrated in few hands. So now what Parliament did? Parliament made a law. Now suppose let's make a hypothetical law. Okay, now friends, this is not a real law. I am just giving you example so that you can understand. So this is a hypothetical. Okay, so now suppose Parliament made a law and the law was that any person who is earning more than 10 lakh rupees, he has to spend half of his income. He has to spend 50% of his income in the welfare of poor people, for the welfare of poor people. Okay, so now suppose if a person is earning 20 lakh rupees in a year, so now he has to spend 10 lakh rupees for the welfare of poor people. Okay, now definitely the person has earned 20 lakh rupees, so these entire 20 lakh rupees are his property. Okay, so and right to property is given under Article 19 clause 1 subclause F and Article 31. So Article 31 and Article 19 clause 1 subclause F is right to property, and definitely the money earned by a person is his property. So actually this law is depriving a person of his property. Why? Because this law is forcing a person to give half of his property for the welfare of poor people. Means actually this law is made to enforce Article 39 clause C. Why? Because this law is preventing the concentration of wealth in few hands. Why? Because if person will earn X amount of money, then he has to actually donate half of the amount for the welfare of poor people. Okay, so this law is made to give effect to Article 39 clause C, but this law is violating Article 19 clause 1 subclause F. Moreover, this law is violating Article 31, right to property. Okay, so now Article 31 capital C is saying that only on this ground that this law is violating Article 31, Article 19 or Article 14, this law cannot be declared unconstitutional and void. So now Supreme Court or High Court will not declare this law as unconstitutional, void or invalid. Okay, now further Article 31 capital C is saying that now this law cannot be questioned in the court of law. Means no legal case can be initiated against this law. So this was Article 31 capital C. Now let's see further. Then friends, what happened? That 25th Amendment Act was challenged before Supreme Court in Kesbanand Bharti case 1973. But the court upheld the validity of the act. Okay, so what happened? The 25th Amendment Act was challenged in Kesbanand Bharti case 1973, but the court upheld its validity. So what 25th Amendment did? So 25th Amendment Act actually inserted a new article in the Constitution, and that article was Article 31 capital C. And what Article 31 capital C was saying, that if any law is made to give effect to DPSP under Article 39 clause B and 39 clause C, and in the process if that law is violating Article 14, 19 and 31, then only on that ground that law will not be declared unconstitutional and void. So now Supreme Court is saying that Article 31 capital C is perfect. There is no problem in this article. Okay, so court actually upheld its validity. Means court said that this provision is constitutional, this provision is correct. But friends, Article 31 capital C was saying one more thing. So Article 31 capital C was saying that any such law cannot be questioned in the court of law. So now court said that this law is invalid. Okay, so it struck down the clause that law cannot be challenged in the court. Okay, so now Supreme Court struck down the clause, means declared that clause an invalid and void. Which clause? That the law cannot be challenged in the court. Okay, so what Supreme Court did? Supreme Court actually upheld the validity of the act, but then Supreme Court said that the clause which is saying that the law cannot be challenged in the court is unconstitutional and void. Okay, so court has its power to do judicial review, and any law should be produced before court. Okay, so this is what court was saying. Now friends, what happened, that Parliament enacted 42nd Amendment Act 1976, which among other things amended Article 31 capital C. Now what does it mean? So it means that now what Parliament did, Parliament again amended the constitution, and now through this amendment Parliament again amended Article 31 capital C. Means Parliament again changed the language of Article 31 capital C. So now what was the new language of Article 31 capital C? That if states enact a law to give effect to any DPSP, and in the process the law violates fundamental right under Article 14, 19 and 31, then the law shall not be held unconstitutional. So now what is changed? So here you can see that earlier it was DPSP under Article 39 clause B and 39 clause C, but now it is any DPSP. Okay, so this was very big controversy. Okay, so they inserted any DPSP. So actually what Article 31 capital C was saying, that if government makes any law, okay, and government is making that law to implement any DPSP, to implement any directive principle of state policy. So earlier they were saying that if government is making any law to implement DPSP under Article 39 clause B and Article 39 clause C, but now they are saying that if government makes any law to implement any DPSP. Okay, so please put your attention on any DPSP, and if that law violates fundamental right under Article 14, 19 and 31, then that law will not be held unconstitutional and void. Okay, so friends, then what happened, that subsequently through 44th Constitutional Amendment Act 1978, Parliament removed Article 19 clause 1 subclause F and Article 31 from the lists of fundamental right. Now what does it mean? It means that Parliament again amended the constitution, and this time what Parliament did, Parliament removed Article 19 clause 1 subclause F and Article 31 from the list of fundamental rights. And what were those articles? So Article 19 clause 1 subclause F and Article 31 were actually right to property. So in short we can say that Parliament actually removed right to property from the list of fundamental rights. Now friends, then what happens? Then came Minerva Mill case 1980. So what happened in Minerva Mill case 1980? So Supreme Court turned down the changes brought in Article 31 capital C through 42nd Amendment Act on the grounds that it was disturbing the balance between Part 3 and Part 4 of the Constitution, which itself is the part of the basic structure of the Indian Constitution. Okay, now what does it mean? So it means that through 42nd Constitutional Amendment Act, Parliament changed the language of Article 31 capital C. So earlier what was the language of Article 31 capital C? So earlier its language was that if state makes any law to implement the DPSP under Article 39 clause B and Article 39 clause C, and in the process if it's violate fundamental right under Article 14, 19 and 31, then that law will not be declared unconstitutional and void. But when Parliament amended the constitution, but when Parliament bought 42nd Constitutional Amendment Act, then through that act, Parliament actually changed the language of Article 31 capital C. And now what was the new language of Article 31 capital C? So now the new language was that if state makes any law to implement any DPSP. So earlier it was DPSP under Article 39 clause B and Article 39 clause C. But now Article 31 capital C was saying that if states makes any law to implement any DPSP and if in the process it violates the fundamental right under Article 14, 19 and 31, then that law will not be declared as unconstitutional and void. So now court is saying that this change is unconstitutional. This change is actually disturbing the balance between part 3 and part 4 of the constitution. Okay, so if actually any law is trying to implement Article 39 clause B and Article 39 clause C, and in the process if it is violating fundamental rights under Article 14, 19 and 31, then it's okay, no problem. But now if you are saying that any law is giving effect to any DPSP, and in the process if it is violating fundamental rights under Article 14, 19 and 31, then that law cannot be declared as unconstitutional. So this is wrong. This is actually disturbing the balance between part 3 and part 4 of the Indian Constitution. Okay, this is giving arbitrary power to the state. This is actually reducing the value of fundamental rights. Why? Because if this law is remained in operation, then government will make any law and government will try to reduce the effect of Article 14, 19 and 31. Okay, so what Supreme Court said? Supreme Court said that the changes brought in Article 31 capital C through 42nd Amendment Act are unconstitutional and void. Why? Because these changes are disturbing the balance between part 3 and part 4 of the Constitution. And balance between part 3 and part 4 of the Constitution means balance between fundamental rights and DPSP is a part of the basic structure of the Indian Constitution. So Parliament, even by Constitutional Amendment Act also, cannot change the basic structure of the Constitution. So Parliament cannot disturb the balance between part 3 and part 4 of the Indian Constitution. Parliament do not have any power. Parliament does not have any power to disturb the balance between part 3 and part 4 of the Constitution. Why? Because it is the part of the basic structure of the Constitution. So now what happened? Now Supreme Court declared the change brought in Article 31 capital C through 42nd Amendment Act as unconstitutional and void. So now Article 31 capital C reverted to its original form. Okay, now friends, then court said that court also declared that power of judicial review of court cannot be taken away. Okay, so now what court said? That actually the power of judicial review of court is also the part of the basic structure of the Constitution. So now what Supreme Court is saying? That the power of judicial review is the part of basic structure of the Constitution. So Parliament does not have any power to snatch this power from court even through constitutional amendment. So Parliament does not enjoy any power to snatch the power of judicial review from the court. Why? Because power of judicial review is also a part of basic structure of the Constitution. Now friends, what is the present condition? So present condition is that under Article 31 capital C, two directive principles of state policy under Article 39 clause B and 39 clause C can prevail over two fundamental rights under Article 14 and Article 19. Why? Because definitely Article 31 is now no more a fundamental right. Now what does it mean? It means that if what is present condition? So present condition is that if state has made any law and that law is made to give effect to DPSP under Article 39 clause B and Article 39 clause C. And in the process, if that law violates the fundamental right under Article 14 and under Article 19, then that law will not be declared unconstitutional and void. Okay, so present condition is that the DPSP under Article 39 clause B and Article 39 clause C can prevail over fundamental rights under Article 14 and under Article 19. So this is the present condition of this entire story. Now friends, then a very basic question arises that why directive principles of state policy are not enforceable in the court of law. So Article 37 says that DPSP are not enforceable in the court of law. So the question arises that as why DPSP are not enforceable in the court of law. So the answer is that DPSP are not enforceable because in 1950, means when our constitution was made, when India was made, okay, when our state was made, at that point of time we didn't have enough resources to provide everything. Okay, so in 1950 means when our constitution was enforced, when actually India was made, at that point of time we were having very limited resources, so we didn't have enough resources to provide each and everything. For example, friends, what Article 44 says? So Article 44 says that achieve uniform civil code. But in 1950, at that point of time, people didn't have that much of consciousness. People were lack in consciousness. Okay, means people preferred to be governed by their religious laws, by their traditional laws in their personal matters. Okay, and even if you will see today's condition, present condition, then also now also people are not conscious. Now also people are not conscious when it comes to personal matters, when it comes to religion. Okay, so how can you imagine that people can be conscious in 1950? So at that point of time people were not conscious enough to accept uniform civil code. Okay, so constitution makers did not involve uniform civil code in the fundamental rights. Constitution makers involve uniform civil code in the DPSP. Means when state will have enough resources, when there is correct time, at that point of time government will implement uniform civil code. Okay, and I can give you one more example, that what is Article 45. So Article 45 says that government should provide free and compulsory education, and earlier it was for 6 to 14 age group, and now it is for the children whose age is less than 6. Okay, so what happened, friends, that Article 45 says that government should provide free and compulsory education. Okay, now at that point of time, means in 1950 we didn't have enough teachers and money to open schools. We didn't have enough money to pay salaries to teachers. We didn't have enough money to open new schools. Means government didn't have enough resources to provide free and compulsory education. That's why right to education was initially not included in the fundamental rights. It was included in DPSP. Okay, but later on when government had enough resources, when government gained enough resources, so what parliament did? Parliament amended the constitution and parliament inserted a new article, Article 21 capital A. And now we have right to education as our fundamental right. So friends, DPSP are not enforceable. This is not because they are inferior to any other part of constitution. Okay, so DPSP have not been given automatic enforceability, not because they were inferior to any other part of the constitution, but the goals in the principles require much resources and time to achieve them. Okay, so DPSP have not been given automatic enforceability, means they are not enforceable in the court of law, not because they were inferior to any other part of the constitution. Okay, actually they are equally important as other provisions of the constitution are. Okay, so they were not inferior to any other part of the constitution, but the goals and the principles, the goals given in DPSP required much resources and time to achieve them, which may not be possible at the disposal of the state. Means when the India was made, when the constitution was made, and thus no time frame was set to achieve their goals given in DPSP. So now no time frame was set to achieve the goals given in DPSP. Okay, so now we can jump to the conclusion that DPSP are also equally important than to other parts of the constitution. Okay, but when our state was made, when India was made, at that point of time we didn't have enough resources. Okay, so these principles were made not and non-enforceable. Okay, means we cannot compel the government if government is not implementing these principles. So this is the first importance of DPSP. Now friends, again we will discuss about the importance of DPSP, means importance of directive principles of state policy. So Dr. Bhimrao Ambedkar pointed out that these principles act as testing ground to measure the performance of the government. Okay, so Dr. Ambedkar pointed out that these principles act as testing ground to measure the performance of the government. Means if any government is responsible to people, okay, any government which is responsible to people shall have to implement them, otherwise it will be answerable to people in the next election. Now what does it mean? So it means that if any government actually wants to do welfare of people, if any government is actually responsible to people, then whenever this government will make any law or policy, then that government will include the provisions of DPSP in its law and policy. Means that government will make its law and policy according to the principles of DPSP. Now what does it mean? So friends, I will give you one example so that you can understand it very easily. So we know that there is party politics in India. So here I will not take the name of any political party. Here for the sake of understanding, we will assume some political parties. So suppose there are 4 political parties: Party A, Party B, Party C, Party D. Okay, and suppose there is the government of Party B in the center. So Party B is ruling in the center. Okay, so now friends, if Party B, the government led by Party B, if Party B actually wants to do welfare of people, if the government of Party B is actually responsible towards people, if they are actually worried about people, then whenever they will make any law or policy, okay, whenever they will make any law or policy, then they has to make that law, they have to make that law or policy according to the principles given in directive principles of state policy. Okay, so if they are really worried about people, if they are really responsible toward people, then they have to make their laws and policies according to the guidelines, according to the principles given in DPSP. Okay, and if they will not do so, then they will have to give answer to the people in the next election. Okay, so if they will not make good laws, if they will not make good policies for the people, then people will not give vote to them in the next election, and they will lose the election. Thus we can say that these principles may not be enforceable in the court of law, but they are enforceable in the court of people. Okay, so what does it mean? It means that even though these principles are not enforceable in the court of law, means if government are not enforcing these principles, then we cannot file a legal case against the government in the court of law. We cannot force the government to implement these principles, but actually these principles are enforceable in the court of people. Means in the next election, when the party will come to people, when party will go to people for vote, then people will not give vote to that political party who will not make their laws and policies according to the principles given in DPSP. Okay, so if any government led by any political party will not include these principles, will not make laws and policies according to the principles given in DPSP, then the court of people will punish them. Means people will not give them vote in the next election. Okay, so according to Dr. Bhimrao Ambedkar, directive principles of state policy are very, very important. Even though they are not enforceable in the court of law, but they are enforceable in the court of people. If any government actually wants to do welfare of people, if any government is actually responsible toward people, then that government will make its law and policy according to these principles. And if that government will not make its law and policy according to these principles, then people will not give vote to that political party in next election, and in this way people will punish that political party. Okay, so we can finally conclude that these principles are very, very important. Okay, why? Because these principles are actually enforceable in the court of people. Now friends, that's all for today. I hope that you all have enjoyed the lecture. So I have given the link of notes in the description of the video, and you can also directly download the notes from my blog. You can also follow me on Instagram. My ID is PrashantIAS7, and you can also ask questions from me on Instagram. So friends, if you have enjoyed the lecture, then please like the video, comment, subscribe to my channel, press the bell icon, and till then, take care of yourself. Thank you.